former Additional Solicitor General of India, Shri Ashok Mehta sir, connected with us through a video conference. We also have Advocate Yashraj Singh Bundela sir from the Knowledge Collective, Professor Dr. Alka Chawla ma'am, Professor in charge, Campus Law Center, and also the patron of this event. We have with us Professor Dr. Raman Mittal sir, Professor Dr. Gunjan Gupta ma'am, and Dr. Seema Singh ma'am, who is the program director of this event.
We welcome you all. To begin with, let us take a moment to extend our heartfelt gratitude to our esteemed guests and dignitaries who grace the occasion with their presence today. Their presence adds immense value to this gathering, and we are truly honored that you all could spare a few moments from your busy schedule to be with us here today.
It is indeed a pleasure to have such an incredible audience with us as we come together for the second lecture in the series of Delhi University's pious initiative called Kartavyam, which shall leave you with abundance of knowledge, wisdom, and inspiration.
As we embark on this enlightening lecture series, let's illuminate the path ahead with positivity and wisdom. I would invite the dignitaries for the lighting of the lamp. Let this light symbolize the knowledge and energy that will shine throughout this event, along with the Kulgeet.
The lighting of the lamp
जयति जय जय जयति जय जय ज्ञान का लोक अनुपम
श्रेष्ठ सुंदर दिव्य दिल्ली विश्वविद्यालय विहंगम
जयति जय जय जयति जय जय ज्ञान का लोक अनुपम सकल वसुधा निज कुटुंब की भावना संस्कृति सनातन आधुनिक शिक्षा पुरातन ज्ञान धाराओं का संगम
देश की स्वाधीनता हित भूमिका शतकोटि वंदन
निष्ठा धृति सत्यम के मंगल दिव्य भावों का समागम
जयति जय जय जयति जय जय ज्ञान का आलोक अनुपम
भव्य महाविद्यालयों के परिसरों से चिर सुशोभित श्रेष्ठ गुरुजन कर रहे नित्य छात्र और छात्राएं दीक्षित
सद्चरित्राचार पावन साधना संकल्प संयम
नवल वैश्विक चेतना नव क्रांति संस्कारों का उद्गम जयति जय जय जयति जय जय ज्ञान का लोक अनुपम
श्रेष्ठ सुंदर दिव्य दिल्ली विश्वविद्यालय विहंगम
जयति जय जय जयति जय जय ज्ञान का लोक अनुपम
ज्ञान का आलोक अनुपम
ज्ञान का लोक अनुपम
ज्ञान का आलोक अनुपम
It is our privilege to felicitate the honorable guests. May I now request Professor Dr. Alka Chawla ma'am, Professor in charge, Campus Law Center, Patron of Kartavyam, to welcome our guest Justice Adarsh Kumar Goyal sir, former Judge of Supreme Court of India, who was also Chairperson of the National Green Tribunal, with a memento and a shawl. We are deeply honored to have Sir with us. Sir has delivered many crucial judgments, including the waiving of the 6-month mandatory period for mutual consent divorce in the Hindu Marriage Act.
भाई बता भाई पता तू ना इसकी भी काट सकती थी बट पता इसने तेरी गलत गोटियां चलाई अभी भी कट तू काट दे
We are deeply honored to have Sir with us. Sir has delivered many crucial judgments, including the waiving of the 6-month mandatory period for mutual consent divorce in the Hindu Marriage Act, statutory regulation of polygamy, preventing the misuse of Section 498A IPC, and payment of court-ordered compensation by the state to the victim or his family where the accused is unable to do so. On this significant pendency of cases with the subordinate judiciary, while mandating the timely disposal of criminal cases and supervision by the High Court, Sir had significantly opined that public interest is above individual interest.
May I please request Alka ma'am to welcome our guest, Senior Advocate C.S. Vaidyanathan sir, by presenting a memento and a shawl. Sir is renowned for his humbleness and has made significant contributions in the growth of law. He is the recipient of Padma Shri Award for outstanding contributions to the field of law. Sir has an illustrious career spanning across fields of telecommunication, broadcasting, power mines, along with patent competition and IVC disputes. In addition to those, his practice spans across constitutional law, administrative law, arbitration, and environmental matters. He has appeared for the Government of India in high-value taxation matters. He was the lead advocate in the Ram Janmabhoomi case. He has also advocated for interstate river water dispute cases and election symbol dispute cases and disqualification cases. It is indeed a privilege to have Sir with us today.
I would also like to extend a very warm welcome to our esteemed guest, Sri Ashok Mehta sir, who has graciously joined us today through video conferencing. Sir is currently the Additional Advocate General of the Government of Uttar Pradesh and Organizing Secretary of the Mediation and Conciliation Center at the High Court of Judicature, Allahabad. Sir is also the trustee of Knowledge Collective. Sir has formerly served as the Additional Solicitor General of India at the Allahabad High Court and is a national patron of the Bharatiya Bhasha Abhiyan aimed at making justice available to the weakest section of the society in their mother tongue to enable a better understanding of their rights. Sir has also written Chauri Chaura, a legal perspective which offers a deep legal insight into the 1922 Chauri Chaura incident and amplifies forgotten voices of history.
Moving on, I invite Professor Dr. Raman Mittal sir to deliver the welcome address.
Esteemed guests, my worthy colleagues, and very dear students, it is my proud privilege to deliver the welcome address today in this wonderful seminar, which is second in the series. I would like to start with a small story which was narrated by one of the greatest philosophers this land has ever produced. His name is Jiddu Krishnamurti. He said that he was in search of truth. Thank you. And so intense was his search that he looked here, there, and everywhere. He had left no stone unturned towards his phenomenal search. But nobody could tell him the address of truth. He toiled hard and still harder. And ultimately, with great effort somehow, he was able to find out the address of truth, where truth resided. But there was another problem. That place was very far off. And he didn't have the means to go there. It was a difficult and arduous journey to go there. But he sold his belongings, he amassed his resources, collected all the things required to undertake that journey, and he set himself forth towards that goal. And finally, after much toil and labor, he was able to reach that place and is able to locate that house. And outside the house, he found the nameplate of truth. It said that the truth resided there. He ventured to enter it and found that the door was open. He pushed the door and entered inside, only to find that there was nobody. The house was totally vacant and there was nobody inside it. He came out and inquired from the neighbors that where has the resident of that house gone? The neighbors informed him, yes, somebody lived here, but he has just gone somewhere else now, and we do not know the address of that place. So, my dear friends, by saying so, he emphasized the importance of looking at truth as a journey rather than as a destination. It is a process rather than an event. So, when we are talking about law and morality, morality is not fixed. It is always changing. It is ever moving. And we can progress in the science of law only when we accept this fact that we need to pursue and always keep on pursuing. This is not something that we catch once and for all. Had it been possible, हमसे पहले बहुत आए, हमसे ज़्यादा विद्वान आए, बेहतर लोग आए शायद, तो वो हमारे लिए पकड़कर छोड़ जाते, लेकिन फिर हम क्या करते? हम किस लिए आए हैं? That would have been another question. Why have we been sent here? So, my dear friends, as I said, there are various perspectives to look at this issue of the interaction between law and morality. And this is just one of those. And I would like to narrate another one with the help of a small poem that I had written some time back. Let me, मोबाइल में देखना ठीक रहता है ना, पोएम में तो शब्द इधर उधर हो जाते हैं, तो बोलने में तो दिक्कत नहीं, लेकिन पोएम हो तो थोड़ा देखना पड़ता है. So the title of the poem is Law Goes on a Holiday. Working continuously for ages, witnessing society in all its stages. Now, for some time, he wanted to be away. For once, Law desired to go on a holiday. His wife, now who is Law's wife? If you personify Law, well, I think, can you guess? Order, right? Because I'm married, I know order comes from where. So, his wife Order went along. With their kids, right and duty, they said so long. As away they sped, good riddance, people said. No need for compliance, no fear of defiance. At once the society was absolutely free, and the materialist world was full of glee. But when there were no rules to abide by, promises you could easily defy, everywhere there was arson and loot. Soon every gentleman became a brute. It led to widespread death and destruction, and cessation of all production. There was chaos all around. In a pool of sorrow, the whole world drowned. When people realized that Law was so profound, he was nowhere to be found. On a long vacation, Law had gone to an unknown destination. But amidst all that rumble, upon something else man did stumble. A gentle cajole, a whisper from the soul. From man's conscience deep, morality arose from her vestigial sleep. Obscured under Law's glow, she had lost all her flow. She does not have a fixed description. There is no standard prescription. From the sovereign there is no command. Of compliance there is no demand. Soon, she gave birth to a daughter, responsibility. The daughter had an uncanny ability, a moment-to-moment capacity to respond. To right and duty, she alone could correspond. In the absence of law and the consequent rampage, morality became the harbinger of a new golden age. Law's holiday is extended for a long, long time. He could be away till morality remains in her prime. Thank you so much.
Thank you, sir, for extending such a warm welcome address. Now, I am pleased to inform that we have with us Mr. Yashraj Singh Bundela. Sir is an advocate on record and standing counsel for the state of Madhya Pradesh at Supreme Court. Sir has also authored a well-renowned book called Integration of Bharat, Political and Constitutional Perspective. Sir is also the coordinator of Knowledge Collective and also our knowledge partner. I request him to say a few words.
Thank you very much. Om. Respected dignitaries, Honorable Justice Adarsh Goyal, Senior Advocates Shri C.S. Vaidyanathan sir, former ASG Shri Ashok Mehta ji, who is connected with us online, Professor Alka Chawla ji, Professor Dr. Seema Singh, Professor Mittal, Professor Gunjan Gupta, all the faculty members present here, all the volunteers, advocates, and students. Today, I welcome you all on this August gathering of our Constitutional Law Lecture Series commemorating the 75th year of the Constitution making with the theme of Kartavyam. Today, on this occasion, I am deeply honored to have been provided with this opportunity of introducing the knowledge partner of this program, which is Knowledge Collective. Knowledge Collective, probably this is the first time all of you would be hearing this name. So, Knowledge Collective is an organization which aimed at working amongst the legal professionals, advocates, academicians, students, and institutions to act as a bridge to foster original thinking, legal research, legal writing, legal drafting, policy making in the field of law, covering every possible aspect which renders and makes justice accessible to every section of the society, especially that towards which the justice delivery still seems a distant dream. Knowledge Collective slowly expanding and trying to create a pan-India organization having its presence across all the states, union territories, institutions, colleges, and universities. Knowledge Collective acts as a catalyst to support the culture of legal discourse amongst all the participants of the legal fraternity. Knowledge Collective wants to work with the objective of fostering the ideas that are enshrined in our Constitution, especially in the preamble. For example, the unity and integrity of the nation, supremacy of our Constitution, the ideas of liberty, equality, fraternity, and last but not the least, to move towards the Kartavya-oriented society from right-based society. Therefore, Knowledge Collective is not just an organization, but it is a movement in which all of you are participants and active workers. Thank you very much.
Thank you, sir, for your insights. Now, let us take a moment to understand the significance of today's event. The lecture for the day will emphasize on the concept of constitutional morality, invoked in the history by Dr. B.R. Ambedkar in his November 1948 speech, The Draft Constitution, and more recently in monumental cases like Navtej Singh Johar versus Union of India 2018 and Joseph Shine versus Union of India 2018. Baba Saheb argued that constitutional morality was not a natural sentiment, but a necessary ideal for the functioning of a democratic polity, requiring a culture of respect for the Constitution and its institutions. I request Dr. Seema Singh, the program director of this event, to give an introduction to this historic event. I shall be failing in my duty if I don't mention that ma'am is also an author having 3 books to her name and has written many articles and publications. Ma'am, we would be humbled if you could please introduce today's event. Thank you.
Thank you so much. Welcome to all of you in this second lecture of Kartavyam. First of all, I would like to welcome Honorable Justice Adarsh Kumar Goyal ji, Vaidyanathan sir, respected Alka Chawla madam, Gunjan madam, Raman Mittal sir, Yash Raj, and all of you, all the faculty members and students sitting in front of me. Once Nani Palkiwala ji has said, the survival of our democracy and the unity and integrity of the nation depend upon the realization that constitutional morality is no less essential than constitutional legality. Dharma lives in the hearts of public men. When it dies there, no constitution, no law, no amendment can save it. In recent past, we have heard many times this term constitutional morality, which has been frequently used in the various judgments by the Supreme Court, from decriminalizing Section 377 of IPC, decriminalizing adultery, and the entry of women in Sabrimala temple. But there is one very important statement which is given by Honorable Chief Justice, Justice Deepak Mishra ji, where he said, in case of conflict between the constitutional morality and the social morality, we will protect constitutional morality. Now the important thing is there are many issues where we can easily see that there is a conflict between the constitutional morality, which has been declared by the judiciary, and the social morality. It is a very important issue to decide that what is the contour, what is the domain, what is the parameters of the constitutional morality. And today, the basic purpose of choosing this topic for this as a second lecture, I personally believe that we are definitely going to understand the actual purpose, the actual meaning, and the actual jurisprudence of constitutional morality, which is very, very important. And I think it is high time to define at least the outer limit of constitutional morality, whether it is the morality of a judge, whether it is a morality of a law, whether it is a morality of society, or it is a morality of constitution, and whether there is any difference between the constitutional morality and the societal morality, if societal morality is as per moral norms. So with this, I just close my statement. I welcome you all, and I will request you, all of you, to participate, to listen very carefully, and to participate very actively, because this session will also be ended with a question-answer round. And I request all of you to ask some good questions with the learned speakers sitting on the dais. Welcome you all, and thank you so much.
Thank you, ma'am, for enlightening us about this exciting event, which will not only help the students but also the professionals of law. We are delighted to inform our audience that the team of Kartavyam has tried its best to fulfill our Kartavyam towards the environment by going eco-friendly this time, by reusing all decorations and reducing our carbon footprint. Moving on to a very special part of today's event. Now, may I now invite Senior Advocate Ashok Mehta sir to address us. Sir, may I request you to kindly share your words of wisdom.
former judge of the Supreme Court. Really, I am working and have been interactive with you for the last 35 years, since 1991-92 itself. My extreme brother, colleague, C.S. Vaidyanathan ji, lovely to have you here on the dais. Yashraj, yes, after a long, I heard you. Well, the faculty is still represented by Dr. Raman. कवि आप पहले हैं, लॉयर आप बाद में, जूरिस्ट आप बाद में. मैडम सीमा, अब आपसे रिक्वेस्ट करूंगा कि इनके पहले लेक्चर की और इस लेक्चर की दोनों पोएम को इनसे लेकर के एक बार मेरे पास भेज दीजिए. मैं एस्ट्रिक लगा करके अपनी बना करके बोल दूंगा, बाद में बोल दूंगा रमन पोएम. नो मैच टू इट. लेकिन एक बात अच्छी लगी, फैकल्टी में आप घिरे हुए हैं मैडम अलका से, मैडम सीमा से, मैडम गुंजन से. अब फैकल्टी को टेक ओवर लेडीज ने कर लिया है. इट इज अ गुड एम्पावरमेंट ऑफ द गर्ल्स. एंड नाउ आई एम श्योर दैट द morality is in safe hands, very safe hands. Yes, I'm worried a little, but now I'm coming on the subject itself. But before the constitutional morality, I want to state certain facts. भारत एक आध्यात्मिक राष्ट्र, a spiritual country. इसके अपने शाश्वत मूल्य हैं और उन मूल्यों में नैतिकता भी है. यह राष्ट्र सांस्कृतिक राष्ट्र और भारत की संवैधानिक इतिहास में संस्कार गुथा हुआ है. ये मैं नहीं कह रहा. 1960s में ग्रिनवेल ऑस्टिन ने किताब लिखी, कॉर्नर स्टोन ऑफ ए नेशन. फ्रेंड्स, आई रिक्वेस्ट यू ऑल प्रेजेंट इन द ऑडिटोरियम, प्लीज यू मस्ट गो थ्रू इट. It is really the history of the Constituent Assembly, how it worked, how it developed. It is often cited book in the Supreme Court and by the research scholars also. He said कि ये एक seamless web है. अगर मैं इसको, अब मैं इसको दूसरे तरीके से कहता हूं, ये एक, हाँ क्योंकि तीनों लेडीज हैं इसलिए कहूंगा, ये एक बनारसी साड़ी है जिसमें डेमोक्रेसी, सोशल रिवॉल्यूशन और प्रिजर्वेशन ऑफ यूनिटी एंड इंटीग्रिटी आपस में गुथ करके एक साड़ी बना दी. लेकिन उस वक्त जब कॉर्नर स्टोन ऑफ ए नेशन लिखी तो एक जरी का जो काम होता है वो उसको भूल गए. ऑस्टिन ने 97 में दोबारा मेहनत करी और तब उन्होंने वर्किंग ऑफ द डेमोक्रेटिक कॉन्स्टिट्यूशन जब 99 में आई, तब उन्होंने कहा देयर इज ए फोर्थ मेटाफोरिकल मैट्रिक्स इन दिस सीमलेस वेब, एंड दैट फोर्थ थ्रेड इज द जरी, जो सोने की होती है. वो जरी इस रेशम की बनारसी साड़ी में मौजूद है और उसका नाम है कल्चर. He adds this fourth feature of culture to the seamless web of the Banarsi sari. That is Constitution of India. It is sometime visible, sometime omnipresent, sometime invisible. लेकिन ये अब अगला वर्ड मैं यूज कर रहा हूं. भारतीय संस्कृति सनातन है. रमन जी ने सत्य को बता ही दिया है कि सत्य कहां है नहीं मालूम, लेकिन कंटिन्यूअस प्रोसेस है. लेकिन उसमें एक श्लोक है, सत्यम ब्रूयात प्रियम ब्रूयात, न ब्रूयात सत्यम प्रियम, प्रियम च नानृतम ब्रूयात, ईश धर्म सनातन। कितना सुंदर है। रमन जी ने उस बात को बहुत ही पोएटिक वे में कहा था। मैं उनके साथ, उनकी बातों के साथ एकदम एग्री करता हूं। मैं ही नहीं, ये देश भी एग्री करता है, क्योंकि भारत का ध्येय वाक्य है सत्यमेव जयते। इसी समय मैं दूसरा वाक्य भी कहना चाहूंगा। सुप्रीम कोर्ट जहां कॉन्स्टिट्यूशनल मॉरलिटी के ऊपर लंबी डिबेट्स होती, बड़ी लंबी डिबेट्स होती, और फिर कुछ जजमेंट भी आते हैं, वहां हर जज की कुर्सी के पीछे ऊपर लगा हुआ है एक ध्येय वाक्य, यतो धर्म ततो जय। मैं जब सुप्रीम कोर्ट जाता हूं तब उसी को देखता रह जाता हूं। वहां सीजे कोर्ट नंबर 1 में 2 पोर्ट्रेट भी हैं, लेकिन हर बार एक पोर्ट्रेट को मैं नमन करता हूं, और वो पोर्ट्रेट है कोर्ट नंबर 2 में। फ्रेंड्स, अगर आप लोग नहीं गए हैं तो जरूर जाइए। HR खन्ना का पोर्ट्रेट आज भी ऐसा लगता है कि कोर्ट नंबर 2 में मौजूद है। वो उनकी कोर्ट थी, ही रिटायर्ड फ्रॉम दैट, बट स्पेसिफिकली फॉर द ट्रुथ। इस समय आकर के कॉन्स्टिट्यूशनल मॉरलिटी और सोशल मॉरलिटी को क्योंकि कंपेयर करना है, उनके कंटूर्स को रखना है, तो मैं केस लॉ पे आऊं उससे पहले मैं एक ही बात कहूंगा। मॉरलिटी की सोर्स जब कॉन्स्टिट्यूशनल मॉरलिटी की बात होती है तो कॉन्स्टिट्यूशन है, सोशल मॉरलिटी की बात होती है तो सोसाइटी। उसका फोकस कॉन्स्टिट्यूशन में प्रिंसिपल्स पर होता है, लेकिन सोसाइटी के अंदर उसका फोकस वैल्यूज और मूल्यों और नैतिकता पर होता है। एनफोर्स करने के लिए कोर्ट्स हैं, लीगल फोरम्स हैं, लेकिन सोसाइटी के अंदर कल्चर और संस्कृति है जो उसे एनफोर्स करती है। अब आपस का रिलेशन, कॉन्स्टिट्यूशनल मॉरलिटी में कंट्राडिक्शंस और कन्फ्लिक्ट्स आते हैं, और उनको एडजस्ट करने का काम उसका इन सोसाइटी। लेकिन जो सोशल मॉरलिटी होती है वो इन्फ्लुएंस करती है लॉ। अब जरा समय के हिसाब से बात करते हैं। मैं एक बात प्रिंसिपल ले डाउन कर रहा हूं, जैसा समाज वैसा नेतृत्व, जैसा समाज वैसा नेतृत्व और वैसा ही न्याय। इसका एग्जाम्पल दिया जा सकता है। जी हां, 1980 में मैंने बार ज्वाइन करी, और 18 जनवरी को एक एक्ट आया। इंदिरा गांधी तब दोबारा जीत करके वापस आई थी, और इमीडिएटली एक एक्ट आया। एक्ट का नाम था ब्लैक मनी बॉन्ड। व्हाट ए ग्रेट वन। I must tell you what it was. अशोक मेहता ने आज तक कभी भी टैक्स, इनकम टैक्स सन 80 में 12 जनवरी तक नहीं पे किया, और टैक्स के करोड़ों रुपए बचाए। आप जो मेरे सामने समाज बैठा है, इसने बहुत रेगुलरली टैक्स पे किया, पूरा टैक्स पे किया। लेकिन 1981 के अंदर अशोक मेहता से सरकार ने कहा, यस यू परचेज आवर बॉन्ड्स विद योर ब्लैक मनी, वी विल नॉट आस्क फॉर इट, व्हाट इज द सोर्स ऑफ इट। एंड देयर आफ्टर 5 years we will double it. What a great idea. It was challenged by R.K. Garg and R.K. Karanjia, reported in 1981. Yes, that case is still disturbs because of the reason the great persons, great personalities, they are still the legends of Honorable Supreme Court. They said, yes, it is their words. The courts are concerned only with the constitutional validity of the act. अगली लाइन बड़ी खतरनाक लगी और आज भी दिल में चुभती है, and not with its morality. एक आदमी था, द फिफ्थ जज, ऑनरेबल मिस्टर जस्टिस, उन्होंने खुल के कहा, सॉरी, I will never justify immorality. Immorality can never be reasoned. I am not in favor of immorality. I am also not in favor of the great विकृतियां जो हमारे यहाँ हैं, जैसे कि पहले बलि होती थी, फिर सती भी थी, छुआछूत अभी तक नजर आता, विधवा विवाह, बाल विवाह, ये सब मेरे समाज की विकृतियां हैं और इनको सोशल कल्चर के बेसिस के ऊपर कभी भी सोसाइटी में, आज की सोसाइटी में जस्टिफाई नहीं किया जाता। लेकिन अभी दो बातें आई थी, एक आया एडल्ट्री और एक आया 377, इनवैलिड हो गए। लेकिन सोसाइटी के अंदर, फौजियों के अंदर लॉ आज भी नहीं इसको रिकॉग्नाइज नहीं करता है। देयर इट इज स्टिल द ग्रेटेस्ट मिसकंडक्ट फॉर विच द गिल्टी पर्सन इज ऑलवेज removed from service, dismissed from service. When they were asked, please change your law, the army refused, the military refused to do so. Well, is it not prevailing even after holding it to be invalid? Just look into any jail, you will find it random, rampant. And in juvenile law schools, rampant. Please, if we are really worried about the constitutional morality, each and every one of us should work for it to remove it. एक केस तो वो हो गया। एक दूसरा केस, मेरे वकालत में आने से पहले ही इमरजेंसी लग गई थी। एडीएम जबलपुर में 4 जजेस ने कहा, सॉरी, नो पेटिशन, no locus to anyone, no locus to anyone to file any petition. Even if a person is killed, his whereabouts will not be known. You can't still challenge it. Yes, only one person was there, Honorable Mr. Justice H.R. Khanna. Law of preventive detention without trial is an anathema to personal liberty. Remarkable words. सच में उन्हें अमर कर गए। उनके लिए चीफ जस्टिस ऑफ इंडिया शिप बहुत छोटी चीज थी। एक तीसरा बात मुकदमा मैं यहां कहना चाहता हूं, समाज, नेतृत्व और न्याय के साथ नरसिंहा राव केस, करप्शन का केस, करोड़ों रुपए की रिश्वत लेकर के सदन के अंदर वोट करना आपको प्रिवेंशन ऑफ करप्शन एक्ट में ऑफेंस से इम्यून रखता है। आई एम शॉक्ड, आई वॉज शॉक्ड इन 95 when this judgment came. लेकिन यहां पर क्वेश्चन इस बात का है कि जैसा उस समय का समाज था, जैसा उस समय का नेतृत्व था, उसी प्रकार का न्याय था। ये गौर करने की बात है, फॉर्चुनेटली एकदम भगीरथ कार्य किया डीवाई चंद्रचूड़। 44th अमेंडमेंट आ चुका था, कोई जरूरत नहीं थी कि ओवररूल करा जाए। लेकिन आधार के जजमेंट का मैं बेस्ट पार्ट अगर मानता हूं तो डीवाई चंद्रचूड़ का वह पार्ट है जहां उन्होंने स्पेसिफिकली कहा है कि आर्टिकल 21 डज नॉट कन्फर ए राइट टू लाइफ और पर्सनल लिबर्टी। आर्टिकल 21 assumes and recognizes the fact that those rights exist and afford protection against the deprivation of these rights to the extent they provide. ये सिरवई के शब्द थे, कोट हैं उस जज में। और फिर उन्होंने कहा है लाइफ एंड लिबर्टी आर इनएलिएनेबल टू ह्यूमन एग्जिस्टेंस They constitute rights under natural law. The human element of life of the individual is integrally founded on the sanctity of life. Dignity is associated with liberty and freedom. Neither life nor liberty are bounties conferred by the state, nor does the Constitution create these rights. What a great words these are. The right to life has existed even before the advent of the Constitution in recognizing the right. The Constitution does not become the sole repository of the right. The right to life being inalienable to each individual, it existed prior to the Constitution. Here comes the morality. Here comes my culture. Here comes the Sanatan truth. It is accepted by the court. एक और जगह है जहां accept हुआ, बड़ा famous judgment है. The famous is known as, case is known as Tulsi Ram Patel. Dismissal without inquiry. वहां पर ये स्पष्ट कहा, the principle of natural justice are not the creation of Article 14. Article 14 is not their begetter, but their constitutional guardian. Principle of natural justice trace their ancestry to ancient civilization and centuries long past. I don't feel anything more has to be said, but I will just say and close my arguments with these words. ये संसार ऋग्वेद का ही है. ये संसार किसने क्रिएट किया था? Whether the creation is sustained by the creator or not is known to him only, who superintends this creation from the supreme space, or it may not be known even to him. शायद क्रिएटर को भी नहीं मालूम है कि ये सत्य कहां से आया. इस प्रकार मैं मानता हूं कि उच्चतम न्यायालय भी स्वीकार करता है कि मानव मूल्य मानवता के साथ ही साथ मान्य हुए. भारत का संविधान, मौलिक अधिकार, जीवन एवं समता का भी उन्हीं सनातन मूल्यों की पहचान और मान्यता. एकम सत्य विप्रा बहुधा वदन्ति. स्पष्ट है, यहां सत्य को व्यवहारिक बनाने और उपयोग में लाने का मार्ग बताया गया है. और अगर ऐसा नहीं होगा तो वही होगा जो रमन जी की कविता में हुआ था. मैं इन्हीं शब्दों के साथ फिर एक बार कहता हूं, सत्यमेव जयते यतो धर्म ततो जय. नमस्कार.
Thank you, sir, for such a well-researched and inspiring speech. It is now our privilege to move on to the much-awaited address by our esteemed guest, learned advocate C.S. Vaidyanathan, sir. Please join me in welcoming him with a huge round of applause.
Good evening to all of you. I'm privileged to be sitting with Justice Goyal, with whom I practiced in Supreme Court. Mr. Ashok Mehta, Professor Alka Chawla, who has taught my children, Professor Raman Mittal, Professor Gunjan, Dr. Seema Singh, all the young faculty members and all the young and vibrant students. I'm privileged to be here because my children went through this same campus. They both passed out of Campus Law Center, of course, a good more than 25 years ago. So I can tell you that you're all so lucky This campus has produced a good number of judges, academics, intellectuals, and leaders. And therefore, you can be proud of studying here. I don't want to give a lecture for a number of reasons. Number one, I see before me bright, young, and vibrant students who can think on their feet. And therefore, I would much rather have a meaningful debate. Number two, Mr. Mehta has expatiated on the subject. And today with ChatGPT and Google, you just have to put in the two words, constitutional morality, and you will get a whole lot of answers. Therefore, I don't want to go into that. But I want to raise specific issues, and I would like a debate. I want to start with the law of defection in 10th schedule of the Constitution. Legislators get elected standing mostly on party tickets, where some of them, very few of them, as independents. 10th schedule sets out circumstances it will be considered as defection. But if it is a sizable section splitting away, then of course it's not treated as a defection. What is your reaction to a person who has stood on a party ticket and then changing his party, alliance, views, whatever you may call it? Is it constitutionally moral? Or is there something which you will deprecate, which you will say is constitutionally immoral and therefore they should be disqualified, which is what the 10th schedule seeks to do, unless you are 1/3 of the total number of persons belonging to a particular party. Should freedom of speech prevail and conscience voting be allowed? Because if conscience voting is allowed, then you are disobeying the whip when you vote against the whip of the party. I would like some responses from you. I want to raise two more issues in regard to the same subject. As and when a complaint is made of defection, and the Constitution has vested the power of adjudication on this issue with the Speaker of the Lok Sabha or Speaker of the Assembly, should there not be some kind of a time limit within which he should decide? If he does not decide, is it constitutionally not just improper but immoral on the part of the Speaker? And as a logical consequence of this, if a grievance is brought to the court that the Speaker is sitting tight over the matter and not taking a decision, is it constitutionally permissible and moral for the court to fix a time limit for the Speaker to decide, or on breach of that time limit to declare that the person against whom the complaint has been made is disqualified, is deemed to be disqualified. Now, I want your views on this. See, this is a very important issue in a democracy. And this is an issue which has been agitating. Even today, the courts are seized of this matter. I would really like some response from you, and then we can debate it. Does anyone have a view?
Just raise your hand now.
Thank you, sir. I am Roshan Jha from second year. As far as defection case is concerned, and another question about speaker's timeline, I think there must be some timeline within which he should decide the cases of defection, because otherwise it will defeat the purpose of the legislation itself. So there must be some reasonable timeline, and recently Supreme Court also told the speaker to decide the cases in reasonable timeline, otherwise we will have to intervene. I think that's the right perspective to see
the contrary view.
Thank you, sir, for giving me chance. Sir, I think there should be time limit, not because just Supreme Court said. Definitely it matters that when the time of the legislative assembly or parliament is limited, how can we let it, open-ended that you can decide even after 5 years? Would it be, would it be possible and would it be justified? It cannot be, sir, in my opinion. Thank you.
I have not had any response in regard to the first issue. How do you perceive the right to freedom of speech and the right of freedom of a legislator to vote according to his conscience, and as against being bound by a whip? Is there any morality or immorality in his voting against the whip?
Good evening, sir. My doubt is regarding the first point which you raised regarding the anti-defection law. As it is not new to our democracy that when a party rakes up an issue during the election, but after they won, they hardly try to follow their ideology. But when a personal member of parliament has his conscience still alive and he wants to vote against his party's whip, then why can't it should not be allowed? Thank you.
Anyone else?
Good morning, good afternoon, sir. My opinion also regarding the freedom of speech, what the members of this assembly have. Usually, whenever a bill approaches the assembly, it's believed on the number of members a party is having, not on the morality of what they think personally. But it is counted, the probability is counted on the basis of how much members a party is having, which in my opinion is totally unfair. Like the members, if they have been elected by people like we as voters, we do surely think that they should have their independent opinion. They should be considering their morality and independently voting, regardless of what their party's manifesto is actually speaking. They should be taking into consider their people's welfare and for what reason they have been elected to that position, what they are sitting right now. So definitely, sir, this independent voting and freedom of speech should persist. Thank you.
See, I am not here to give answers, but I just wanted all of you to sense that there can be differing views. And that is the essence of democracy. That's the essence of freedom of speech. Maybe someday constitutional morality will dictate that a person who has a view different from the view of the party can be allowed to express his view and thereafter resign if he doesn't want to vote in the particular manner in which the party dictated. One doesn't know. But today, as the law stands, he is bound by the whip. Now, I am just giving you an illustration, and I think by and large there is a consensus in regard to speaker having to act within a particular time and the court having to give a direction if necessary, if the speaker doesn't act, that issue. Yes, I would agree in regard to both those. See, I am highlighting this because there can be sharp differences in regard to perception of what is constitutionally moral. I go on to the next aspect of what Professor Seema Singh had raised in regard to constitutional morality versus social morality. See, there are different concepts. You have what is perceived to be majoritarian morality. Morality of the majority of the people. That may not necessarily be the morality of the entirety of the population and may not be also consistent with constitutional morality, as you can see from the preamble or the directive principles of the chapter on fundamental rights. And please also bear in mind that our concepts of morality are today shaped by the colonial rule and the rule of Victorian morality. Nobody thought when Khajuraho sculptures were there that this is immoral. But the sense of Victorian morality which has percolated into each one of us makes us look at it as if it is vulgar. It was never considered vulgar. So also, even the Vedas have spoken about relationship between same sexes. But today, in the concept of Victorian morality, it is considered to be immoral. Now, therefore, these are aspects which we need to keep in mind before we talk about social morality or whether something is an anathema to the society of today. Let me also raise this question of Sabrimala which was raised. For the believers who regularly undertake the pilgrimage to Sabrimala, and mind you, crores of people converge on that hill shrine every year. They believe that Dharmasastra, Ayyappa, is a Nitya Brahmachari. And therefore, women in a particular age group, till they attain menopause, should not go to the shrine. There can be people who can say, you don't have to go to temple, God is within you. But there are people who seek solace and comfort by going to the shrines in which they believe. They have their favorite shrines. So there are a number of people who have faith and belief in Sabrimala. Now, just take the case of a number of Tamil students in South Africa. The case came up. The Tamil student, as per her tradition and culture, had the ears pierced, wore the ear garments, and had flowers and went to the school. School said, we have a uniform guideline, you should not wear this because it is display of religion. Similar cases arisen in India in regard to the Muslims wearing the clothes on top of their head. Now, there is a conflict. There is a freedom to practice religion, to choose the faith of your choice and to practice that, and also certain amount of discipline in the institution, schools or colleges or whatever it is. Now, therefore, these are matters on which there can be no definite answers. If you look at it from the point of view of majoritarian morality, the rule which imposes a uniform standard may be considered to be right. But if the constitutional right is to be given some meaning, then it may be different. Now, do you have any views on this?
So, as you said about Sabrimala, so they had rights in 25 and 26, and those rights were, explicit and expressed in the Constitution. So, and to counter that, the Supreme Court came up with it, concocted this idea of constitutional morality, and they just, imposed that to, restrain people from exercising their rights. So my question is, can something which is unwritten can prevail over the written? Because again, 25, 26, everything is clear. Constitutional morality is nowhere mentioned in the Constitution. So my question is, can something which is unwritten in the Constitution prevail over what is written? Thank you.
No. There is, equally the Constitution talks of, in Article 14, 15, etc., of equality of access to public temples. So there is a direct conflict between the equality of access and the right to practice your religion. Therefore, that's a resolution. You have to resolve it. Now, you also mentioned about something not being written. If this argument is accepted, the entire theory of basic structure falls to the ground. You don't find it. You don't find various other things about collegium, etc., anywhere. Therefore, silences, constitutional silences have been made eloquent, may have been given, infused with meaning and voice, and then they are today guiding. See, these are very, very delicate issues. I think we need to carve out certain exceptions, like in the case of Sabrimala. The person who wants to go there, there are ever so many Ayyappa temples anywhere else. Why must you insist on going only to Sabrimala? That's the only place which bars. You can go to an Ayyappa temple in Delhi, you have at least 5 different temples. Similarly, in various other cities, no women, even in the age group who are barred otherwise from going to Sabrimala, are not prevented. That, I think, is a balancing of the rights. If you want to, if you are serious about, if you really have faith in that Sabrimala Ayyappa, I think certain giving into the faith and belief of those who regularly go there should be adopted. I think these are matters which unfortunately were not taken into account by the 5-judge bench. 4 out of 5. Hopefully the 9-judge bench will resolve and take this into account and find some means of resolving these issues. I think I have already exceeded the time and Justice Goel is waiting. I just threw up some issues and I'm so grateful for the opportunity given to me. I think these are matters which need to be debated by you in greater detail in your classroom, and you have a fantastically young set of faculty members who are always willing to interact with you. You are all so lucky. Thank you.
Thank you so much, sir, for your illuminating address and for beautifully presenting the contrast between different kinds of morality. Your words have left a deep impression on us. And now, the moment we've all been waiting for, it is our honor to welcome His Lordship, Honorable Mr. Justice Adarsh Kumar Goyal, sir, to share his thoughts with us. Let's extend a warm round of applause as we invite him to the podium.
नमस्कार। सभागार में उपस्थित मेरे युवा मित्रों, मंच पर विराजमान आदरणीय प्रोफेसर चावला जी, मेरे पुराने मित्र और विद्वान एमिनेंट सीनियर एडवोकेट वैद्यनाथन जी, सभी उपस्थित फैकल्टी मेंबर्स, यशराज बुंदेला जी। अभी मैं वैद्यनाथन जी की बातचीत सुन रहा था और आपके सामने अशोक मेहता जी ने भी विचार रखे। आपका आज का जो ये गोष्ठी का विषय है, कॉन्स्टिट्यूशनल मेरिट मोरालिटी एज पार्ट ऑफ कर्तव्यम लेक्चर सीरीज, इंटरेस्टिंग विषय है और वैद्यनाथन जी ने आपके सामने बड़ा अच्छे तरीके से आपके क्वेश्चंस को रेज किया है जिस पर आप विचार कर सकें इस विषय को समझने के लिए। ये लॉ फैकल्टी और नॉलेज कलेक्टिव, इनका ये प्रयास, मुझे आशा है ये सब आपके लिए बड़ा उपयोगी होगा। जो रूटीन में आप क्लास में पढ़ते हैं वहाँ ऐसे विषय कई बार नहीं आते और विचार करने के लिए विचार करना बड़ा आवश्यक है, केवल पढ़ना काफ़ी नहीं है। यंग जनरेशन इज नॉट बाउंड बाय व्हाटएवर state of affairs is there. They have a right to have their own thinking, what the world should be, what the law should be. तो जो संविधान में लिखा, जो कोर्ट के निर्णयों में लिखा, आपके लिए वो काफी नहीं। आपको विचार ये करना है कि समाज के लिए क्या उपयोगी। संविधान भी कोई एक फिक्स्ड सब्जेक्ट नहीं। डॉक्टर अंबेडकर ने भी कहा था कि जो संविधान बन रहा है ये आज की जनरेशन की थिंकिंग है। किसी भी जनरेशन को ये राइट नहीं है कि सब आने वाली जनरेशन्स की थिंकिंग को बंद कर दे, और अगर उपयोगी नहीं है तो डॉक्टर अंबेडकर ने पार्लियामेंट में 3 सितंबर 1953 को आंध्रा स्टेट की फॉर्मेशन की डिबेट में उन्होंने कहा संविधान उपयोगी नहीं है तो मैं इसको जलाने को तैयार हूं। तो संविधान की उपयोगिता, कानून की उपयोगिता, इस पर चर्चा होना और यंग जनरेशन को इस पर डिबेट करना बहुत ही आवश्यक है। वैद्यनाथन जी ने कहा आप जो मर्जी विचार करिए, फिर विचार करिए, विचार नहीं रुकने चाहिए, विचार का प्रवाह चलता रहना चाहिए। ये दिस इज द ब्यूटी, हाउ द माइंड शुड ग्रो, यंग माइंड शुड ग्रो। अब संविधान भी बदलता रहा है और बदलता रहता है, विचार भी बदलते रहते हैं। 106 बार संविधान अब तक बदला जा चुका है। 106th अमेंडमेंट was last in 2024. for reserving 1/3 seats for women in Lok Sabha and state assemblies. तो ये संविधान में उस समय विचार नहीं था. आज की जनरेशन, आज के पार्लियामेंट में ये विचार आया. अब कुछ चीजें हैं जो नहीं बदलती, वो हमेशा वही रहेंगी. जैसे संविधान कहां से शुरू हो रहा है, कैसे शुरू. आपके सामने ये भी बात रखी, संविधान से पहले की स्थिति क्या थी. क्या संविधान से ही वो राइट्स मिले हैं या वो राइट्स पहले भी थे, ये भी चर्चा हुई. केशवानंद भारती के केस में, जिसकी हमेशा हम चर्चा करते हैं, वो पढ़ना आवश्यक है. मैं सभी स्टूडेंट्स को जरूर ये मैं चाहता हूं कि केशवानंद भारती को जजमेंट को जरूर पढ़ें, क्योंकि यही एक ऐसा निर्णय है जिसमें सुप्रीम कोर्ट के सभी जजेस इकट्ठे बैठे, 13 जजेस, और 13 जजेस में से 9 जजमेंट्स, 6 जजेस एक तरफ हैं, 6 जजेस एक तरफ हैं, और एक तीसरा विचार भी है जो कुछ 6 जजेस की तरफ, एक विचार वाले 6 जजेस की तरफ, कुछ दूसरे विचार वाले 6 जजेस की तरफ. तो वो विचार क्या है. वो विचार ये है कि भारत का जो संविधान का प्रियम्बल है, उसमें जो वैल्यूज हैं, वो वैल्यूज क्या है ये हर जनरेशन डिटरमिन कर सकती है, बट दोज वैल्यूज आर इटर्नल. इसका हम बेसिक स्ट्रक्चर भी बोलते हैं. इसलिए आर्टिकल 368 जो केशवानंद भारती में विषय था, पावर ऑफ अमेंडमेंट, 25th अमेंडमेंट में कॉन्स्टिट्यूशन को अमेंड किया गया कि आर्टिकल 13 विच डिफाइंस लॉ, कॉन्स्टिट्यूशन अमेंडमेंट इज नॉट लॉ. नंबर 1, 368 में सब आर्टिकल 4 and 5, court can't question amendment because amendment is constitution. Court is set up under the constitution. Court can determine constitutionality with reference to the constitution. This was the subject, very, very, very complex subject. तो अब सारी इंटरप्रिटेशन एक शब्द पर हुई. फाइनली, this constitution will stand amended if you follow this procedure. What is this constitution? So ultimate view, Keshwanand Bharati, yes, you can amend constitution, you have the power. This power was always there. कोई भी संविधान, कोई भी कॉन्स्टिट्यूशन फिक्स नहीं हो सकता, उससे तो सोसाइटी रुक जाएगी. फ्रॉम टाइम टू टाइम इट इज ए लिविंग ऑर्गन. फ्रॉम टाइम टू टाइम नीड्स ऑफ द सोसाइटी आर टू बी आंसर्ड बाय गवर्नेंस प्रोसीजर, गवर्नेंस सिस्टम which is there in the constitution. So what is the system needed so that needs of the society can be met? Always it can remain changing. Therefore, you can amend. And that power is there. But then, amend this constitution. Identity means this constitution's identity has some fixed identity. हम किसी भी व्यक्ति की सर्जरी हो सकती है, ठीक है, लेकिन उसका जो स्ट्रक्चर है, उसकी पहचान खत्म नहीं होनी चाहिए. हमारी पहचान क्या है, हमारे संविधान की पहचान क्या है, इस पर भी विषय हुआ. और केशवानंद भारती में भी मेजॉरिटी और माइनॉरिटी सब जजेस ने कहा कि ये पहचान के बारे में कुछ बिंदु उन्होंने आइडेंटिफाई किए, कुछ बिंदु चिन्हित किए कि ये पहचान है, लेकिन ये फिक्स नहीं है. अब 3 तो बात है ही कोई भी व्यक्ति संविधान के प्रियम्बल को देखता है तो तीन चीजें सामने, इक्वालिटी, लिबर्टी, फ्रेटर्निटी। ये जीवन मूल्य है, ये संविधान के मूल्य, ये संविधान में अपनाए गए। लेकिन इनका कंटेंट क्या है, इस पर हमेशा डिबेट। इक्वालिटी एक सिचुएशन में आप कह सकते हैं ये इक्वालिटी है, ये लिबर्टी है, आपको यहां तक की छूट है, यहां तक की स्वतंत्रता है, आपका कोई अधिकार का खंडन नहीं हो रहा है। अभी जैसे बात चली थी सबरामली में जाने का मेरा अधिकार है, पर हर अधिकार की भी एक सीमा है। अंबेडकर ने कहा इक्वालिटी एंड लिबर्टी मस्ट लीड टू फ्रेटर्निटी, ये उन्होंने सीमा बताई अंबेडकर। Equality and liberty, if they compromise with fraternity, if they don't result in brotherhood, you can check that liberty or equality there, that it is resulting in lack of fraternity or unity and integrity of the country. These are ultimate values: fraternity, unity, integrity. Subject to that, you have equality, you have fraternity, you have liberty. So, this is how the Constitution is growing. This is how there have been amendments. This is how there have been judgments. Ultimately, we're coming to the subject. Kartavyam lecture series, Constitutional Morality. यस, आपने बुंदेला जी ने शुरू में कहा और सीमा जी ने भी कहा, जिन्होंने ये कार्यक्रम के जो आयोजक हैं। कर्तव्यम, दिस इज द वैल्यू टू बी सीन। यू वांट द मूवमेंट ऑफ द कॉन्स्टिट्यूशन टुवर्ड्स ड्यूटीज फ्रॉम राइट्स। Very valuable thought, and there have been always debates, conflict in right and duty. Today is a thought, today is a debate, conflict in constitutional morality and public morality or social morality. Is there a conflict? And if there is a conflict, where do we end? Can there be any state answer? Is this the last word? What has been said in Navtej Singh, Johar, or Johan Shine, or other judgments? Can we take it as a last word? Or we limit it to the issue there? Is that a permanent ratio? That wherever there is a conflict, public may think anything, but constitution morality will prevail. Where is the constitution morality, somebody may ask? Where is it defined? If something is undefined, how it will be identified? But Mr. Vaidyanathan was just now answering to similar question, that there are silences in the Constitution which are made eloquent by interpretation. Yes, there are. Basic structure is one such thing. It is not seen, it is there. Its basis is there. Not that you are bringing something new which is not mentioned. You are doing it by understanding it or by interpretation. Equality is there, therefore this right will be there. As you know, it's a very, very basic, small legal proposition which is known to everyone. A.K. Gopalan was one first and very important issue which came before the Supreme Court when Supreme Court was set up. उसमें विषय क्या था A.K. गोपालन को डिटेन कर दिया गया, बड़े लीडर थे वो, पॉलिटिकल पार्टी. He challenged the detention law, right to life and liberty, right to move about freely. और उसमें majority view by Justice Kania, at that time Chief Justice. There was a minority view of Subbarao or no, Fazal Ali. Fazal Ali was the minority. Kania was the majority view. So Kania said, procedure established by law means there has to be some procedure, there has to be some law. That's the end of the matter. This is the limit. We can't cross it. We are interpreting the Constitution as it stands. That is the oath we take. We have to interpret the law as it stands. So law, enacted law, is enough to comply 21. आपने कानून बना दिया है, उसमें प्रोसीजर ले डाउन कर दिया है, आप लिबर्टी और लाइफ को टेक अवे कर सकते. No violation of 20. So this was the Gopalan view, which prevailed for a very long time. But does it prevail today? It doesn't prevail. It stands overruled. What is the view today? 21 says life and liberty you can't take away. Procedure established by law means it must be fair, reasonable, and just procedure. Who will determine? Who will determine? Court will determine. So therefore, liberty or life is not merely physical existence. It means anything which makes life dignified. That is your right to life. So what is your content of right to life? Anything which makes, so it's very, very vast. Liberty. Liberty will include, liberty has been held to include right of education up to the age of 14, which was there in directive principle, is now part of 21. Environment is part of 21. So many rights have been read into 21. You can't take away without procedure established by law, means reasonable, just, and fair procedure. So, in the context of 377 IPC, the issue was considered. And there is a thinking world over, thinking elsewhere in India, outside India, thinking in India. There is vast difference in our thinking and thinking in many other countries. They may call it advanced, whether we want to call it or not, that's. We also have a culture of thousands of years old. It doesn't mean, of course, old is gold, but not that the things remain static, thoughts remain static. They can change. But then, when they should change is a question. The Constitution says, we the people. American Constitution also says, we the people. In American Constitution, we the people doesn't mean people of India. Nor in we the people, Indian Constitution means we the people of America. See, we have our family life. We have to accept thoughts from world over, which is good for the society. We have some evils also. It doesn't mean that society, it is prevalent, it should continue. It can be changed by law, it can be changed by court. Court also makes a law within its limit by interpretation. So this conflict arises if you substitute everything which legislature should do, whether it is possible, whether entire wisdom is there with the judge. Judge is also a human being. No doubt. Majority is not always right. Yes, you're right. But then who is right? Ultimately, who is right? Ultimately, it is the constitution which is right. Because any organ which has been set up by the constitution is to work under the constitution. And you have to interpret that constitution in the light of society's needs. So therefore, to say constitutional morality which is not defined will always prevail over notion of the society's morality is not, perhaps in my humble reading. I'm neither a judge now nor advocate. I'm just a student like you. This is my own thinking. I have a right to think, I have a right to express views as you have. You may agree, you may not agree, you can have your own thinking. I will say it is not a proposition which will always hold good. That society's morality is always subordinate to constitutional morality as somebody may think. Because who will think, who has a right to define constitutional morality? Yes, in the process of interpretation, Constitution has given powers to the Supreme Court to define what constitutional morality is. But it's a very, very dangerous or difficult path where judge cannot say this is the constitutional morality which overrides society's morality. And whether I have my own doubt, my own views, whether to what extent there was a case going on, ultimately there is a majority-minority view, is same-sex marriage. The right of liberty, where to, how far to go? As I said in the beginning, liberty, equality ultimately must lead to fraternity. Yes, established thinking of the society. What is in these days in the Western world, people are not getting married. It's my liberty, I will live with anyone. Two adults can decide to live the way they want to live. No third person can question. All right, maybe so. Maybe so, that's law in India also. I'm not commenting on that for the time being. But then, can you make a law irrespective of what your values are, irrespective of what the parliament says? I will say this is the constitutional morality, which gives you right same-sex marriage. I will make a law that there can be same-sex marriage. What will happen to the society? So consequences on the society is a very, very important consideration, if at all any court goes into this issue. That's the view of majority, fortunately, of the 3 judges out of 5 in that particular case. But these cases will come. Many of you will go to the bench. Many of you will go to the administration. Many of you will go to the parliament. So, but this important subject has to be thought over, pondered over. I agree with Mr. Vaidyanathan. So I'm not giving a conclusive, I'm also not giving a conclusive view except saying this. And I also don't want to take too much of time, but I will also like to say that please give it a thinking. And you are also opinion makers. Form your opinion, informed opinion. That also helps. Court also is guided by informed opinions of opinion makers, of the lawyers, of the jurists, of the students, of the academia. Wherever there is a silence, what morality is to deal with a situation. So the laws are made by parliament. Yes, by and large, presumption of constitutionality. By and large, initially, Supreme Court's role was limited to determine whether a particular legislature is within its limit of lawmaking as defined in Schedule 1, 2, and 3, and also whether they are within the fundamental rights, which is basic minimum guaranteed right, because anything which is in conflict with fundamental right is void under Article 30. So now, with expanded jurisdiction, this debate in academia has become very important, and yes, basic structure theory was to determine constitution amendment only. But constitutional morality, you use the word constitutional morality and say, lay down a particular law or set aside a particular law, is something which necessitates a serious study and thinking on various issues which affect the society. And this seminar will certainly help. But I just want to say one or two more things. There are in our constitution 22 pictures. What it signifies is those 22 pictures are important pictures of events or personalities in our countries. It has picture of Lord Ram. It has picture of Lord Krishna. It has picture of Mahavir. It has picture of Mahatma Buddha, Shivaji, Rani Jhansi, Maharana Pratap. They are representing constitution values. Yes, it's important that there are silences. And the courts may also have to determine what morality is, but the reference point is the constitution. It's not unanchored that you can go on anywhere you want. Anchor is the constitution, and in anchoring the constitution, keep in mind the pictures which constitution makers have printed. That is one suggestion. Then, Supreme Court published in 2016 a very important coffee table book, which is called Courts in India. And that starts with Rig Veda. So constitution is a flow. Two words I just want to use from two judgments. One is Justice H.R. Khanna in ADM Jabalpur, in his minority view, which has been now held to be correct law in Puttuswamy, said, it is not that there were no rights before the constitution. And constitution was made by freedom fighters. They could not have wiped out those rights. Therefore, those rights still survive. Those rights will always be there, whatever be the decision of a government of a day. Article 21 was suspended, but Justice Khanna held. Legality of a government decision of arresting or detaining a person will always be considered by court. How? Second judgment I want to just refer, recent judgment in Nagaraj by Justice Kapadia, where 97th Amendment was under challenge, giving reservation in promotion posts. There, while discussing what amendment is, what original constitution is, he said constitution has not conferred rights, it has confirmed rights. This is the word used. Not conferred, but confirmed. Those rights were always there. Our society is thousands of years old. So what citizens' rights were, in this book, which I just mentioned, it is Courts in India, please study. It says, in our society, dharma was the basis. I will take one or two more minutes to conclude, because I just want to make small comment on this aspect. Dharma was the basis, and dharma means everybody doing his duty. That's how society is sustained. Everybody asserting right and violating others' duty, society can't be sustained. Even Ambedkar said, whatever constitution I made or I may make, it will work if people have righteousness, if people are duty conscious. So therefore this Kartavyam, going towards duties, is a constitution mandate. And this is how the constitution should be interpreted. Why? Because we have beautiful constitution. It has worked in 75 years. Now we are having a dialogue today in this as a part of Kartavyam lecture series, commemorating journey of 75 years and having dialogue on constitutionalism, legal philosophy, evolving jurisprudence to dissect and deliberate upon interplay of rights, duties, and governance. That is your today's theme, as mentioned in your letter. So, what it means? Karmanyev adhikaraste ma phaleshu kadachan. So we are duty-based. I will do my duty, you do your duty. If that happens, there will be no problems. 75 years, there are serious problems. Courts are having more than 4 crore cases. Why? Duty consciousness is not there. Can't be brought by court. This requires initiative at social levels, which are not there because in Western world, basic jurisprudence is constitution or government and citizen relationship is social contract theory. All right, I give you the text, you do the rest. Nowhere society's duties, individuals' duties. So individuals' duty, society's duty to promote constitution or protect rights can be meaningful. Constitution can be meaningful only if there is consciousness of duties and at social level there is enforcement of rights at social level and by individuals and the society. Thank you.
Sir, आपने कुछ questions पूछे हमारे students से. Sometimes, you know, they're not able to give an answer because they hesitate to speak in front of the audience, and especially when their peer group are sitting here. But I found out that some people want to ask certain questions from them. If anyone is there who wants to ask a question, you may please raise your hand. Quickly take the mic to that boy, please.
Namaskar, sir. Sir, my name is Shivam Kumar and I want to ask this question कि what are the standard and essential ingredient of constitution morality? और दूसरा मेरा क्वेश्चन ये है कि जैसे कि अशोक मेहता सर ने कहा था कि भारतीय संस्कृति की जो मूल है वो सनातन है, तो और हमारा जो मॉरल है वो अभी भी मूल की बात की जाए तो भारतीय समाज में साहस, वीरता, त्याग, तपस्या और स्वाभिमान को हम मोरालिटी मान करके अपना काम करते हैं. तो उसके साथ में कॉन्स्टिट्यूशनल जो मोरालिटी की बात की जाए और सोशल मोरालिटी जो साहस, वीरता की हम बात कर रहे हैं, तो कहीं ना कहीं यह आपस में कॉन्फ्लिक्ट करेगा या नहीं करेगा? थैंक यू वेरी मच सर.
बिल्कुल नहीं करेगा, बिल्कुल नहीं करेगा. कॉन्स्टिट्यूशन में कहाँ लिखा है कि आपके अंदर साहस नहीं होना चाहिए या वीरता नहीं होनी चाहिए? होनी चाहिए. कॉन्स्टिट्यूशन तभी चलेगा जब मोरालिटी होगी, और मोरालिटी वही है जो सनातन में है, वही हमारा विचार है. अगर उसमें कोई बुराई है, यस, उसको विचार किया जा सकता है, बट बड़ी वैल्यूज हैं. जो आपने साहस और वीरता की बात की है, ये तो बड़ी वैल्यूज है. साहस और वीरता होगी तो संविधान ठीक चलेगा. उसकी कमी है जहां पर, वहां नहीं चल रहा.
Anyone else? Yes, please. अपना सवाल, if you want any particular person to answer, you can direct the question to that person.
Good evening, sir. I have a question to Honorable Sir C.S. Adhanathan, sir. Sir, in the Sabrimala case, the contention of the respondent was that Lord Ayyappa was a Nastic Brahmachari. The temple premises was a lawn of him. So even if the menstruating woman entered the premises, so it would get dirty. So, and with respect to the social consciousness of the people believing in Lord Ayyappa, the Honorable Supreme Court upheld the constitutional consciousness of the public. So, and one of the honorable MPs always, I hear him that he says that the judges or the Supreme Court is not infallible. So, the fair criticism or the fair comment, so what is the line of that fair comment? We can actually question the judges with regarding to that.
See, I don't know whether any of you have gone to Guruvayur temple. You know, if a child, say of 1 or 2 years, enters the temple and urinates, you can't control a child. You know, the whole temple is shut down, some purification ceremonies take place, and thereafter, again, worshippers are allowed. Now, this is a practice which has been followed in the temple, and the believers have the view that, yes, it is. But for us in our house, if a child passes urine, you don't consider the house is polluted. Now, these are some beliefs in regard to places of worship, which those who practice that particular religion have faith in. Now, should that be ignored? Should that be forgotten? See, therefore, by your forcing those who are in a particular age group into the Sabarimala temple, if the believers feel that the temple will get polluted, are you not affecting their right to practice religion, their faith? Therefore, I think we have to balance. There are ever so many Ayyappa temples, Sasa temples, where persons who believe in that, who say that, no, this restriction should not be there, can still go and worship. Therefore, I think we need to try to evolve some kind of a balancing of interests. I just gave one example. There are temples, you know, which say that men should not come at all. Yes? That's, the believers follow that. Now, why should the men go and force themselves into that temple? This is the faith. So, I think we need to give respect, give the freedom, some amount of flexibility in regard to these aspects.
Thank you, sir. एक कर्तव्य हम सबका अपनी तरफ है, to have a living, and for us and for our family. And another kartavya, which not many people realize, senior advocates leaving their practice, coming here for all of you to, you know, I think that needs an applause. इनकी एक हियरिंग की फीस हमारा पूरा साल का खर्चा उठा सकती है. So वो सब ध्यान में रखते हुए we'll just get 2 more questions and then we'll stop. Yes, sir. Yes, quickly. Yes.
Hello, sir. My question is to Honorable Justice Adarsh Goel, sir. Sir, if I limit myself to the constitutional morality debate, so if we see Naz Foundation case and the case of Navtej Singh Johar, we see that cumulatively the constitutional morality takes precedence over the societal morality. Whereas in the Suresh Kumar Kaushal case, we see that the societal morality takes precedence somehow over the constitutional morality. So how do you determine what exactly should take precedence, whether it is constitutional morality or the societal morality, sir?
This has to be founded on the Constitution itself. Whether in a particular case it is constitutional morality, whether there is a conflict in social morality and constitutional morality. Personally speaking, as far as possible, court should never use an expression there is a conflict in society's morality and constitution. Constitution represents society. Constitution is there to serve the society. So there is no conflict. You have to harmonize that some people in society may think 377 is required, some may think it is not required, and who should take a call, whether legislature should take a call, or situation is such that it violates fundamental rights which court itself is to enforce. So this has to be basic approach. It was possible to strike down 377 also by saying it violates fundamental right without invoking this constitution morality issue. It's a very, very dangerous, sensitive, but yes, certainly I don't rule out that there can be issue. Constitutional morality basically means constitution, nothing more than that. Of course, anyone's thought against constitution can be held to be against constitution, and therefore court can say this is the situation or this is the legal interpretation. So using the word pitting the court or pitting the constitutional morality against the society is, personally speaking, not a very good idea.
Sir, just adding one word to it. मेरे पास जब भी कोई प्रॉब्लम लेके आता ना स्टूडेंट, so I always tell them, think from your perspective, think from all the students' perspective, think from the perspective of a teacher, and think from the perspective of the administrator who's sitting on the chair. So now you give me an answer, should I do this or not? And I have found that mostly people walk away. Whenever they come with their problems, they just go away, they say, मैम क्या है, आप इतनी सारी चीज़ें बोल देते हो, इतना सुन के इतना बैलेंस करना बहुत मुश्किल काम है. And to balance morality of various aspects, I think is a very, very tough job. लेकिन एक बात मैं ज़रूर बोलूँगी, जब भी आप आँख बंद करके अपने आप से सवाल करो, आंसर पता चल जाता है कि मोरालिटी क्या है, राइटियसनेस क्या है, अंदर से आत्मा क्या बोल रही है. कोई स्पिरिचुअलिटी किसी गॉड की तरफ जाने की ज़रूरत नहीं है. You will yourself know what exactly is the right path for you. I think many of you must have experienced that a number of times. One more question, please.
One more line I wanted to add,
Yes,
madam,
sir.
if you permit. See, if you read jurisprudence, there were always two thoughts, naturalist thought and positivist. Okay, Blackstone and Austin, these were the jurists which were always taught in law colleges. I also, as a law student, read them. So there has always been conflict. Naturalistic thinking means what the nature says. So that is the law. And positivists say, no, what the law is enacted, that is the law. Yes, what the law is enacted is the law, but it's not rigid or fixed. There are always gray areas which law doesn't answer. So those questions have to be answered. Therefore, both the theories are not absolute. Naturalist theory or positive theory or constitution morality theories towards naturalist jurisprudence thought.
Sir,
And
Delhi University...
express words of the constitution is positivist jurist thought.
Delhi University is the first university which has started with what we refer to as Indian knowledge system, or हमारा जो jurisprudence है, how it is to be read in the Indian context, because we don't want to highlight conflicts. I would say there are no conflicts. It's how you have to move to a particular direction, and that is the
That's
direction of righteousness.
I
So
refer to
तभी
the
justice और न्याय बच्चों को
I refer
समझाना
to
बड़ा
the book
मुश्किल.
Courts in India, which Supreme Court itself has published in 2016, where our ancient jurists' thoughts are discussed in that book. So therefore, we are having been under British administration, only limited to British thinkers as the only thinkers.
Yes.
Forgetting that we have our own jurists who had much more knowledge and who have expounded things in much better way. So it's high time we start also reading our jurists.
Absolutely.
and
So
find
the
solutions.
idea is not to have a war between the East and the West. The idea is to know what our, traditions think of. So one question that you wanted to ask. Yes, sir. Quickly, just one last question.
Okay, thank you. My question from both of you, sir. My question is regarding judicial reform. we know that there is a lot of pending cases in lower courts and high courts. What kind of reform is needed in so that the pendency can be reduced especially in lower courts and high courts, so that faster and efficient justice can be provided to citizens, and the more faith in the judicial system can be ensured for the citizens?
Most important reform is being duty conscious, making citizens duty conscious, because large amount of litigation is unnecessary, frivolous, and duty consciousness, honesty, integrity, these are the values. If these values are there, there may be very, very less litigation left.
True. Now I would request Gunjan Gupta to please come and deliver the formal vote of thanks. A big applause for our guests and the audience.
Thank you, Professor Alka Chawla, with such encouraging and wonderful words, always making us realize that duty sabse pehle hai. As we have come to the close of this incredible event, that is the second lecture of Kartavyam series, I, Professor Gunjan Gupta, on behalf of the Campus Law Center, would like to extend my heartfelt gratitude and thanks to Shri Adarsh Kumar Goyal ji, former Judge, Supreme Court of India, for taking time out of his busy schedule to be here with us. Sir, we are very, very thankful to you. Sir, your inspiring words and invaluable insights have really added immense meaning to today's gathering. Sir has remarkably noted that the young generation has a right to decide what the world should be and not what it is written already. Thinking, contemplating is important. Just studying the books is not sufficient. He discussed the landmark case of Keshwananda Bharti. He introduced fraternity, unity, and integrity, and the last, that is duty, as the three pillars of the Constitution. Sir has encouraged us, individuals as a society, to help evolving it. Sir left us with a question that who has the right to define the constitutional morality? So that's the thought. He said we have to do vichar. I would also thank Shri Ashok Mehta ji, former Additional General of India, for joining online and for sharing his views. Sir, we are very thankful to you. Sir, in fact, has introduced us to the works of Austin, who recognized democracy, beliefs, and culture as the cornerstones of Indian Constitution. His personal experiences from his practice were not only interesting, but valuable insights. He beautifully remarked, "Jaisa samaj, vaisa netritva, vaisa nyay." Sir made us understand the cornerstones of Constitution with the metaphor of a Banarsi sari. He beautifully tried to draw a distinction between constitutional morality and societal morality. I really thank you, sir. I would also like to thank Shri C.S. Vaidyanathan, Senior Advocate, Supreme Court of India, for your presence and for encouraging us with your words of wisdom. Thank you, sir. Sir has really had a different way of addressing us. Sir engaged the audience with the thought-provoking questions about the freedom of speech and anti-defection law. Sir gave us a holistic views of morality by dwelling into the essence of our Constitution. Sir, in fact, also discussed by giving the example of Vedas and Khajuraho's. He said there are different forms of constitutional morality, that is Mediterranean and Victorian morality. Thank you so much, sir. I would also thank Mr. Yashraj Singh Bundela, Coordinator, Knowledge Collective, for his presence and addressing the gathering today. Thank you. I also would thank all the 16 universities connected online with us for today's event. And I would fail if I do not thank our professor in charge with so much of energy always, and with so much of patience, calm, and composure. She's always there standing with us. And as I just said, whenever we go with a problem, she's always saying that you need to understand the perspective of different beings. So not only with the students, it's with among the fellow colleagues also. She's always there to, as a strength of pillar and solving all our problems. A big I would also thank in line our dear colleague, Professor Raman Mittal, for giving the welcome address and for being connected with us throughout and always inspiring through his beautiful motivational stories and poems. Thank you, sir. And last but not the least, I would say a big, big thanks to Dr. Seema Singh, the director, for this Kartavyam series, and for her entire organizing team for their tireless efforts behind the scene, which made Kartavyam a smooth, memorable, and impactful experience for everyone present today. Every small detail, every arrangement, what we see here today is all because of the efforts made by all of them. A big round of applause for them. I would also fail if I do not express the deep appreciation to all our volunteers who had stood as the backbone for the event. And finally, a huge thank to each one of you and for all the participants, the audience, and our well-wishers for your enthusiasm, your engagement, and your presence. Your involvement is what gives Kartavyam a true spirit. Thank you so much for... So as we conclude this second lecture, we move forward. Let's carry the essence of today with us. The spirit of responsibility, action, and service, because Kartavyam is not just an event, it's a continuous call to action. Thank you so much. Jai Hind, Jai Bharat.
खड़े होंगे, एक प्लेज लेंगे और उसके बाद नेशनल एंथम गाएंगे. प्लेज है, सब मेरे पीछे पीछे बोलेंगे. मेरा कर्तव्य, तुम्हारा कर्तव्य, हम सबका कर्तव्य. ये सब हम फॉलो करेंगे. ठीक है, खाली बोलना नहीं है मेरा तुम्हारा हमारा. हम सब अपने इस कर्तव्य को मानेंगे. और अब इसके साथ हम नेशनल एंथम गाएंगे और फिर उसके बाद समापन है हमारे इस प्रोग्राम का.
अधिनायक जय हे भारत भाग्य विधाता, पंजाब सिंध गुजरात मराठा, द्राविड़ उत्कल बंगा, विंध्य हिमाचल यमुना गंगा, उच्छल जलधि तरंगा. तब शुभ नामे जागे, तब शुभ आशीष मांगे, गाहे तब जय गाथा. जन गण मंगल दायक जय हे भारत भाग्य विधाता. जय हे, जय हे, जय हे, जय 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 हे.
Volunteers, please stay back. Yeah. And please leave space for the guests. And yeah.
I got the answer. That is exercise. If we have.